the Tyler Robinson case, which is, of course, about the assassination of Charlie Kirk. Tyler Robinson said he did it. No one is even arguing otherwise, except people on Twitter who want to get paid, period. That is all part of the problem, not a solution. So what is the reality? This.
I just asked him in person if what he said was true the night before, and he said it was. I started crying a little bit and said he wishes he hadn't done it.
And what he had said, the night before, which we have the text records of, is that he killed Charlie Kirk. Today, though, here's the curveball. We expected the judge to make his ruling as to whether or not there's enough evidence to proceed to trial. Probable cause. No-brainer. Lowest standard that there is. The judge says, I hold my decision until September. Why and what does this mean for the defense? Criminal defense attorney Sara Azari knows the answer. Thank you for joining, my friend, especially on a Friday night. So why didn't he rule?
Well, Chris, you know, in a normal prelim, the prosecution puts on its case of probable cause, which they did. The defense makes a motion to reduce the charges and or to dismiss the charges, and the judge rules right there on the spot. There's no taking it under submission. I think in this case, you know, partly I think, you know, some say this is to buy time, which I don't think it's necessary. This is a death penalty case. I think the defense could get time if they asked for it. I think from what I've seen is that this defense wants a very robust record, not just an oral record that a court reporter transcribes, but a written record. In other words, they're forcing the prosecution's hand to brief their position of probable cause and cite to Utah law as to why they think there's sufficient evidence to proceed to trial. So I think this is just the strategy of this defense, and, you know, rightfully so, because their client's life is on the line.
So I didn't put it the right way. It's not the judge that's forcing this to go to September. It's the defense. Oh,
yeah. The defense asked for briefing, and I believe the prosecution has a certain amount of time to present their brief. The defense then responds to it.
That makes sense.
And then the prosecution replies to it, and then the judge has an oral hearing on the briefing and then rules on it. Very extensive, very drawn out. This is not normal.
Appreciated. You made a very good point I would like you to make again, which is ordinarily probable cause is established by a grand jury in an indictment. Here, Utah has this process, and you say this is a unusual and very good opportunity for the defense. Why?
So, Chris, in many states, for example, California, where I practiced for many years, the typical scenario is to file a complaint and charge the defendant and then go to preliminary hearing. We don't as often have grand jury indictments like you do in New York. However, a grand jury indictment is a probable cause hearing that the grand jury decides. And so the defense has no opportunity to cross-examine or challenge the evidence at that stage. In fact, nobody from the defense is present in the courtroom. With a situation like this, where the defendant is charged by a complaint and then there's a preliminary hearing, there is a benefit to the defense because the defense gets an opportunity to cross-examine and challenge the evidence before it goes to trial. And that's something that is, you know, unique to criminal cases, or I should say in civil cases, you get a lot of opportunities to depose. You don't really get that in a criminal case. So this is the opportunity for the defense.
If the defense had, it wasn't him, he was with somebody else, he was compelled to do it, he didn't know what he was doing, would they bring that up now or not yet?
I mean, Chris, this is not a whodunit case at all. I think if the defense went there, they would lose the jury in 2 seconds. They might as well plead to the sheet now. I think the idea here is it's not about guilt, it's about death, and it's about saving their client's life. And so every move the defense makes in this case is around that issue of how do we get rid of the death penalty, from the death eligibility factor of, you know, firing in a crowd where other lives were endangered, to mitigating it in the penalty phase. I mean, that is really the focus here. It's not who else did it. I mean, that's not the case here at all.
What do you make of the suggestions, not facts, okay, but the suggestions that that kind of weapon could have never committed this kind of injury, and the Charlie Kirk people did all this stuff to the scene, and there was a bullet found on the roof, like this is a Kennedy situation? Do you buy any of that?
Are you talking about the ballistic issue that was elicited in the preliminary hearing, or are you talking about the conspiracy theories? Because those are two very different things to me.
Well, the ballistic thing was just about the rifling on the barrel, which often doesn't match precisely. But all of the other stuff that's in the universe of suspicion, which you could call the conspiracy stuff. I
mean, I think it's so whack. I mean, look at, for example, they said he's still alive, right? You had, I mean, there was 5 days of testimony, 40-something exhibits. You have, you know, autopsy talking about the dead body of Charlie Kirk and how he was killed. So there's that. Israel did it. You know, evidence pointed to a rooftop in Orem, Utah, not some foreign intelligence situation. Then you have, you know, I don't know what else there was. There was so many things that, you know, the idea that, I don't know, you can name them, but there was like 4 or 5 different theories. But I'm just saying,
yeah, a buddy of ours who's also in your criminal defense game said, let me tell you something. If there's anything to any of that, you know who'd be saying it? His lawyers, not somebody on Twitter.
Right.
So anyway, I appreciate your insight.
Yeah, or saying that, you know, some inside job by the organization. Well, how do you square that with his own handwritten confession? I mean, that doesn't make any sense. It's completely whack.
Well, I appreciate you putting it out there. And I like the lingo. Sara Azari, thank you very much. I appreciate it. Thank you for watching. Subscribe below and download our NewsNation app right now on your phone, and you will get fact-based, unbiased news for all Americans.